So we're moving to the next program, and just a little bit of timing so folks are aware. As you may have seen in the agenda, we have a series of breakout programs and then also a break, which will be happening at 10:15 Central Time. So just so you know, if you need more coffee like I do, that would be a good time to get it. So now really the perfect segue from where things are at in the U.S. and global agricultural and food economy, we move now to managing the supply chain and in particular issues that are going on within the supply chain. So the moderator for that program is my partner, Mark Kaster. Mark is a partner in our regulatory and food and agriculture group. And Mark, take it from here.
Thanks so much, Mike, and good morning, everyone. I'm Mark Kaster, partner at Dorsey's office in Minneapolis. And our first panel, as Mike indicated, is on managing the supply chain. A recent article in a national newspaper carried the headline, 2 months that tore apart the food chain. The article was a graphic presentation on how the coronavirus has crushed the restaurant and hospitality industry while grocery sales have hit record levels. The virus is shaping every part of our supply chain, and some of the changes could be permanent. The pandemic has and will affect the way food is grown and manufactured, processed, and brought to market. We're seeing wild swings in pricing as supply ebbs and flows with changing consumer demands. And as the country lurches and reopens, what will change and how will it affect the business of food? So we have 3 excellent speakers this morning who will help us sort through supply chain challenges. First up is Monica Johnson. Monica is the General Counsel and Corporate Secretary for DARIGOLD, a $2.3 billion manufacturer of milk, butter, cheese powder, whey products that are sold worldwide. They're headquartered in Seattle. DARIGOLD is the marketing and processing subsidiary of the Northwest Dairy Association. Monica has responsibility for DARIGOLD's legal affairs, and she serves as Corporate Secretary for the Northwest Dairy Association. Monica is going to provide us her insights on supply chain management challenges since the start of the pandemic. Monica, lead us off.
Sure. Thank you, Mark. Thank you for the introduction and the opportunity, excuse me, to be part of the panel this morning and this great food summit. Taking a look at this from a general counsel perspective and really looking at it through that lens, the pace of change and the work is absolutely eye-opening. I mean, you contrast that against the backdrop that you just gave us. The shockwaves that are resonating in the marketplace are also resonating within companies. And that sort of rapid change really brings a lot of inherent risks, and the organization has to manage those risks and consider those. And really from a legal perspective, you know, it's the legal department's responsibility to help the business meet those goals and really, you know, make sure they're met even in this accelerated change environment. The impacts really present daily challenges to the food industry. I can share with you that at DARIGOLD, we activated our crisis management plans early. You know, we're headquartered in Seattle, as Mark just shared, and also that meant that in January, we were very close to the epicenter as patient 0 was identified here in Seattle and the outbreak that we had in the Kirkland facility. Those real challenges were apparent early, and we responded early. You needed to do that from not only a business standpoint, but your responsibility to your employees and ensuring their safety. In addition, you started to see potentially the failure of both your suppliers and your customers to honor their contracts. Folks who were looking at the commodity pricing that we all just looked at took one look at that and decided that perhaps they would cancel their contracts or seek to cancel them. And, you know, that happens both on a domestic and an international basis. And that's really where the legal department comes in and really looks at, is that truly, you know, an excusable performance event, or is it something else? So really explaining that to the business, working with the business to get through that, and, you know, even hopping on the phone and getting on with the other legal counsels to solve that and to really come to a business solution that helps everybody through this period and continue to move forward. talking about the shockwaves again, when that supply and demand fall out of sync, it's every link in the supply chain. So it's, from farms to manufacturers to transportation to on shelves in the stores. And that's where, at least from the inside company perspective, again, you've got to be nimble, you've got to be agile. So again, not only are you activating those crisis management plans early, but you're having regular, often communications amongst the cross-functional teams. So when your demand is falling out of sync, what's going on the ops side of the house, and are they able to then figure out what the sales needs are and how do you solve for that? And not only is it an operational cross-functional meeting issues, but there's, town halls. You've got to communicate amongst your entire company and be very transparent and communicate early and often as to where the company is, what is happening, and how the company is responding. That definitely leads to the next bullet point, talking about safety first. At DARIGOLD, safety first is our first core value, continues to be, and it also extends to farm safety. We have a responsibility as a co-op to our member owners, and how do we help them ensure that they have farm safety? Because throughout the supply chain, everyone is concerned about the workers, their safety, and their health. It is an everyday issue as well, not only the sourcing of ingredients, but shifting consumer demands and geographical demands. We have alluded to the increase in retail buying and the decrease in dining out. So, yes, there's been some fantastic, recent pricing around cheese, but you also have to consider the demand around butter and milk, and how does that, shifting consumer demand really fit into now a much more retail-centric buying pattern as opposed to a food service buying pattern. Also, just sharing a little bit around, unusual international dimensions. Think about maybe January, February, where things were, really hitting their height in Asia, and you potentially then, based upon the shutdowns there, had the lack of cargo ships coming back to the U.S. Western ports. That inability to ship led to really, obviously impact on our ability to export, but then also, again, the whole business and legal partnership around what's a force majeure and how do you invoke that, when do you invoke that, and can you? If we move to the next slide, talking about the issues and the progression of them, and we've talked about, it's all aspects of the supply chain, and it absolutely is. So it's from farms, as the prices drop, as demand decreases as well, and schools and other outlets have increased stockpiles, and couple that also with the retail demand. Again, the concern about workers and having them fall sick or stay home due to lockdowns. Also, one of the things here from an in-house perspective is it's really important to have good relationships with your local regulatory bodies. So you're thinking your local regulatory health bodies specifically here. It's important to be able to articulate what those are, not only to the agencies, but to your workers. And your workers have to really know, understand, and most importantly, those workers have to have confidence in your employee safety program. They have to know that when they come to work, they're going to be protected, that you've taken the necessary steps, not only to screen them as they're coming in, but in the workplace itself. How are you making that workplace safe for them? Also, transportation is a concern as well. We talked earlier about the Farmers to Family Food Box program. That's been a great opportunity, but the grocery orders and other things really don't offset those lost orders from restaurants, schools, and other venues. If we look at the next slide, how are we responding as companies internally? We talked earlier about transparency. Absolutely, transparency is key to all of this, and communicate, over-communicate. At this point, you really can't communicate enough. Things are so rapidly changing from day to day, let alone, week to week. It's important to do that. It's also, taking a look at that inventory management, and again, having those cross-functional teams that are discussing what are the sales side seeing and what are the operations side seeing, and making sure that you have that right. One of the other things too, in the practical internal controls to remember is, your board. So your board of directors, One thing we've done is we've had regular COVID, meetings with them. We get together on a very regular basis, much more than the regular board cycle, and update them on the business and make sure that they are comfortable with where the business is at, that they are monitoring those mission critical tasks, and harken back for the lawyers on the call. The boards have those caremark duties, good faith to ensure an adequate corporate information and reporting system around those mission critical tasks. And as we said, things change a lot in this environment. And sure enough, in June, we had the Bluebell recent Delaware shareholder suits, and talking about what is it that you need to be doing in your food safety programs and quality programs relative to your board. So there's a lot of practical internal controls, yes, but they also continue to evolve, just as everything else in COVID continues to evolve. I'll go quickly through this. Sorry, I just looked at time. Legal review is the traditional, making sure that the agreements are properly done and evaluating those practical options. We've talked about those earlier. And also to legal in the supply chain is also HR. It's in the company supply chain, but not in the external. And it's really, again, making sure that the employees have the information that they need, whether that's a website, whether it's memos, or whether it's their manager, someplace they can get that information. If we look at the next slide, I think really it's understanding that this impact has been enabled by the U.S. companies becoming parts of many global supply chains. International markets are now major revenue sources and sources of supplies. Continue to experience a wide range of disruptions in recent times, and I think that that's only going to continue. All in all, I think here really, if you kind of encapsulate all this together, as companies are turning their focus towards the next phase of the crisis, and this is really going to be a long-term managing of a crisis, and even try to reimagine what the new normal looks like, and then be prepared to change again. I think that this is the impacts of COVID are something we're going to be feeling in the in-house community and supply chain for many years to come. And with that, I'll turn it back to Mark.
Thanks so much, Monica. That was great. So our next speaker is Nelson Dong. Nelson is a partner in the Dorsey Seattle office and advises companies and organizations on export controls, economic sanctions, national security matters, and international law. Nelson is chair of Dorsey's national security law practice and co-chair of the Asia Pacific practice. Nelson has great practical experiences and will be speaking today on disruptions in the international supply chain. Nelson recently published a paper on disruptions, and that paper is included in the materials that you received. It's full of great insights, so please check it out. Nelson, the floor is yours.
Thank you, Mark, and thank you to our co-panelists here today for this opportunity to talk about both domestic and international supply chains. My remarks today are going to focus on some of the key features that we have discovered over the last 2 years in international supply chains. As Monica had indicated, and as Rob did earlier in his economic overview, the U.S. farm economy and the food economy have become increasingly globalized over the past 20 years or so. And that's both on the import and export side. So we have many more opportunities, but with opportunities also come more risk and exposures as these supply chains get longer and longer around the world. And so the feature of this part of the program is really going to go over some of the things that we have experienced over the last 4 years and what that may teach both legal counsel and business executives within the food and ag sector about the contracts that they're relying on. And this would be a good time to reflect on some of those experiences and to go back and revisit some of those key clauses. So the first one I'm going to focus on are the trade and tariff and counter-tariff situations. Both Rob in his comments at the beginning talked a good deal about the trade dispute with China and the imposition by this administration of a number of tariffs. For those of us in the international trade world, those are referred to in shorthand as list 1, 2, 3, and then the 4A and 4B lists of goods made in China that have been subjected to a variety of tariffs up to 25% ad valorem. So that has caused, in turn, a great deal of effect within China itself as a sovereign nation, and they have opted to impose as much as possible retaliatory counter tariffs or other non-tariff trade barriers in an effort to level the playing field, so to speak, with the United States. And that has caused, in turn, quite a bit of consternation within the exporter community in the United States, particularly within the farm sector, because the Chinese felt, for their own reasons, that it made most sense to impose the pain on American exporters in the core of the constituency that had elected President Trump. And so as a consequence, there was a disproportionate amount of attention paid in many economists' and lawyers' eyes against the food and agricultural sector, in particular in the United States. So what does this teach us then about some of the cautions as we review the trade instruments, the contracts for these long supply chains? What it probably teaches us is that we need to look more carefully at price adjustment clauses and to factor in whether you need to deal with imposition, and in some cases very abrupt imposition of tariffs or non-tariff barriers, and how that ought to play out. There is no one size fits all or sort of miracle silver bullet clause that you can write in, but it does require the parties to think ahead about what would happen as we have now seen government behavior in the light of this trade dispute. How should those clauses read optimally to be fair, to be reasonable, to be protective of the core assumptions that went into the parties' original bargain? And so more than ever, it's likely that people need to factor in tariffs and counter tariffs in a way that really has not been necessary over the last several decades. Since the end of World War II, with the formation of the General Agreement on Tariffs and Trade, and then eventually the evolution of that to the World Trade Organization, on the whole, global trade has increased exactly in proportion to the fall off of the use of tariffs around the world. And so at one point, roughly around 2017 or 2018, almost 70% of goods imported in the United States came in tariff-free, and so duty-free. And so that gives you some index of how much the world had evolved since roughly 1946, 47. And now we seem to be in another wave in which we're going to return much more to the use of tariffs in managing international trade. And there are every indication that whoever wins the election in November, the occupant of the White House, will be far more friendly to the use of tariffs in managing American trade relations with its trading partners. And so as a consequence, that really suggests that the food and agriculture industry then also needs to think much more about those provisions in contracts dealing with price adjustments due to such factors. Several of the others have already mentioned the pandemic problems. It's important to keep some historical perspective there because we had the SARS outbreak in 2002, the avian flu in 2009, the Middle East respiratory syndrome in 2012, and so on. And so it's not just COVID-19 that's creating some new opportunities for us to look at how those kinds of events do or do not factor into a typical ordinary force majeure clause. Many such international agreements typically specify that force majeure will include events such as fire, flood, earthquake, riot, war, but on the whole, most are silent on the issue of epidemics and pandemics. There may be some opportunity then to be more specific so that the protective nature of those force majeure clauses will include a clear reference, an explicit reference to pandemics or epidemics or outbreaks of infectious diseases. But then one needs to go one step further and say, the normal force majeure clause is going to be basically a binary instrument. It's either going to excuse performance or require performance. And one might ask reasonably, as you sort of do these tabletop exercises of what ought to happen to a contract's obligations in the event of a pandemic, is a simple on-off switch what you really want, or do you want something more nuanced? Not every supplier, not every purchaser is going to want the same thing. But the point is to remember that even if you specify pandemic as a cause of a force majeure, as a force majeure event, that doesn't end the discussion. It doesn't end the review of the clause, because you then have to look at the effect that's going to result from triggering that clause. Likewise, in this crisis, we've seen, as Monica mentioned a moment ago, the fall off of available shipping because of the pandemic. And so that's another opportunity to look at the logistics clauses and the transportation clauses in these international agreements. And once again, is that an intervening event that ought to be treated as an event of force majeure? And is then once again the binary nature on-off switch, or do you want some sort of a dial instead of an on-off switch built into the contract because of disruptions in transport availability? The last factor I'm going to talk about in this overview today, and I address most of these things more specifically in the paper that you'll be getting, is the increasing creep of economic sanctions and export controls into international business affairs. In the recent past, we have had a massive impact of these kinds of abrupt imposition of trade sanctions and export controls. So many of you may already be familiar with the headlines around Huawei, which is the telecommunications equipment company in China. The administration overnight imposed a rule that put the brakes basically on $11 billion of US exports to one company. And so the kind of tool that was used there legally, today it was used against a telecom company. Next week it could be a major state-owned food enterprise. That kind of authority is ubiquitous, and it can affect other kinds of companies as well. More recently, we've seen a very serious imposition of some of these trade sanctions against Chinese companies that are involved in the export or production of cotton and cotton goods in Xinjiang province. So these are not hypothetical cases. These are real cases indicating that for the first time, even people in the food and agricultural sector need to take those kinds of opportunities and risks into their consideration as they review these kinds of agreements. So with that, Mark, I turn it back over to you.
Thank you, Mark.
Shevon, this is Mike Droke. If you could just do a brief background, because it was hard hearing Mark there, and then bring us home. Thanks.
Great. Thanks, Mike and Mark. As Mark mentioned, I'm going to briefly discuss some of the litigation trends that we're seeing, and they're mainly falling into three buckets. The first is related to contract and business disruptions resulting from disputes with upstream or downstream partners or with insurers. For those types of litigations, the focus thus far has been mainly on force majeure provisions and common law doctrine like impossibility and frustration of purpose. Monica and Nelson have already done a great job of framing some of the considerations that you have to think about with respect to your contracts and various agreements. And others today will also address other ways to safeguard your contracts in the business context of the post-COVID era. I can't stress enough how important it is to take the steps now to implement best practices, especially some of those that Monica just mentioned. But I will also say that even with the strongest force majeure provision, that may not prevent litigation, even with respect to your contracts and agreements. The other types of claims that we're seeing, and I'll spend more time focusing on as others won't address today, are those asserted by employees or customers largely related to alleged exposure to the virus. The two employee-related claims that are listed on the slides are ones that have gotten a lot of media attention. They're both related to meatpacking plants. You've probably seen similar cases filed by farm workers and employees that work in stores such as Walmart or in facilities run by Amazon, and all largely allege that their employer breached their duty of care with respect to safety precautions. The third bucket is similar, but it's an area to watch for those of you that have retail locations, and that is customer litigation, again, related to a duty of care with respect to safety precautions. Up to this point, the majority of the customer-related claims have been filed against restaurants and bar owners related to in-person openings, although we expect that to shift to other types of businesses in the near future. These claims have also taken the form of public nuisance litigation. And with that vehicle, an individual or an organization doesn't even have to be a customer or an employee, but can bring litigation with respect to the safety practices. Since the pandemic really hit the US hard in March, many in the media and lawmakers have predicted that there would be an avalanche of employment and customer related litigation. Just over a week ago, Mitch McConnell tweeted, quote, "Our country can't afford a second epidemic of frivolous lawsuits while we fight the COVID-19 pandemic. The next relief package should focus on four things: jobs, healthcare, kids in schools, and liability protections for those helping us fight the coronavirus." And as I'll discuss in a moment, that liability protection is proposed in the package that was just released, proposed on Monday. But the question is, has there been an uptick in litigation stemming from COVID? And the answer is not quite yet. Up to this point, an organization that's tracking COVID-19 related lawsuits has found that there's been about 3,800, mostly coming in a steady trickle since late March. The vast majority, roughly a quarter, are insurance related. And then there are large chunks that are also related to prisoner civil rights cases and civil rights cases related to business owners that are disputing business closure determinations or stay-at-home orders. About 200 are consumer-related claims, and so far about 400 or so are labor and employment. But again, we do expect that to increase in the coming months, especially given the efforts by the plaintiffs' bar. At this point, it has taken the form of targeted solicitations at large factories or plants in hotspots, in addition to general internet advertising. But I don't think we're far off from the commercials that ask if you or a loved one worked during the pandemic and contracted COVID. And plaintiffs are certainly spending their dollars gearing up for that. There may be other reasons as well why the litigation curve is flattened, so to speak, for the moment. And one of those reasons may be related to shifting regulatory and worker compensation claims. Mike, if you could go back to the prior slide, thank you. Related to, thank you. So one of those reasons may be related to the shifting regulatory standards and worker compensation claims standards. For example, in California, recently they passed legislation that states that for the purpose of workers' compensation claims, it's presumed that essential workers, and that includes farm workers and grocery workers and others within the food supply chain, it's assumed that if they contracted COVID, that they were infected on the job, and puts it on the burden on the employer to prove otherwise. Another area to watch with shifting standards or OSHA regulations, and it's worth noting that the two cases on the slide both had OSHA inspections and no violations were found. Another reason why there has not yet been an uptick may be related to statutory liability limitations. Many states are rushing to adopt them, and they may be on the horizon on a national level. As I mentioned, on Monday, Senate Republicans unveiled their proposal for the next coronavirus relief package. And of course, the media is focused on the roughly $1 trillion package that includes payments to millions of Americans in schools and businesses. But the bill is dubbed the HEALS Act, the Health Economic Assistance Liability Protection in Schools Act, and actually contains a number of provisions with respect to COVID-related immunity. I'll just briefly go over a couple. The first is that it would require plaintiffs to establish gross negligence, defined as conscious, voluntary act or omission in reckless disregard of a duty of care. And so that would be, a higher standard than a lot of the states require in these types of circumstances. It would also require plaintiffs to show that the business failed to make reasonable efforts to comply with applicable federal or state health public guidelines. That means that grossly negligent businesses can possibly escape liability if they can establish that they simply tried but failed to comply with safety measures. It would also bar non-economic damages such as pain and suffering, and would only allow for punitive damages in the case of willful misconduct. And even then, the punitive damages cannot exceed the amount of compensatory damages. The bill also would mandate that any civil suits be filed under a federal cause of action, and that claims filed in state court, the defendant would have the right to remove to federal court. And then the fifth major provision with respect to COVID immunity is that the statute of limitations would be 1 year from the date of actual, alleged, feared, or potential exposure, and that the liability shield would be retroactive back to December 1st. There are also a number of other provisions designed to curtail claims and damages, including requiring a list of places visited and people contacted within the prior 14 days, and also a loser pays provision, which allows prevailing defendants to seek compensatory and punitive damages if a claim outlined in a demand letter turns out to be meritless. So we will see where that legislation goes, but at the moment, there are also over a dozen states that have enacted or are expected to enact liability limitations for businesses and employers. Each have different requirements and varying degrees of protection. Some only protect businesses that are deemed essential, and others provide wider ranging immunity. For example, in Iowa, business owners can't be held civilly liable for exposure absent reckless disregard or actual malice, and the law is retroactive to January 1st, and also shields businesses from exposure as long as they can demonstrate that they substantially complied with applicable federal and state regulations. While in Wyoming, business entities can't be held liable for coronavirus-related injuries if they made a good faith effort to follow the state and local health guidelines. So next slide. So assuming that there aren't applicable statutory bars in place, what are the other roadblocks to liability that we can foresee with respect to these types of COVID-related claims? And one is, what's reasonable? Oftentimes, for many states, plaintiff's burden is measured by a standard of what's considered reasonable. I'm sure some of you remember the dreaded reasonable person standard rabbit hole that many fell down and fell into in torts class in law school. And the post-COVID era, we expect that reasonableness standard to become even more convoluted. What was reasonable in March is far different from what's reasonable now, as Monica mentioned. And that's why keeping up with those standards, those state, CDC, and local standards is critical. The next is, plaintiff's burden of proving causation in the age of contagions. So it's going to be significantly challenging for employees in particular, and also customers, to prove that they contracted the coronavirus while at work rather than through some other means, such as riding public transportation or shopping at the grocery store or from another family member. And this complication is compounded by the fact that the virus doesn't seem to have a uniform incubation period. So it's not as easy as narrowing down a diagnosis and other types of tort claims. So what can we do to stay ahead of the curve and prepare as best we can for litigation in the future? And the first thing is something that you've already heard this morning, and I'm sure you're going to hear throughout the day, and that's to remain vigilant. As Monica and Nelson said, it's important to set up protocols now to monitor the shifting landscape and guidelines. Make sure you have a dedicated person or team in place to do so. I know it's a daunting task, especially for smaller operations, but that's certainly something that the Dorsey team can help you set up and help you implement. Also, shift your goalposts. So under normal circumstances, I think most would advise clients to pick a standard that's above and beyond what's required, so you don't have to continuously revise your policies. But in this post-COVID world, we have to embrace shifting our goalposts to truly protect the business. So that means making timely revisions whenever necessary and having effective and efficient means for communicating those revisions. Another consideration is waivers. Only a few courts have actually evaluated and put to the test COVID-related waivers, but businesses across the country are starting to roll them out in one form or another, whether it be for customers or for employees. And so that may be something that you want to consider, especially given your particular locations of operation. And then finally, organize, execute, and document everything. And I know that that is a tedious task. Most on the call are familiar with all the other forms of documentation for compliance, but I think that the key to derailing future arguments related to a standard measuring reasonableness or proving that there was no breach will hinge on documenting not only the precautions that were implemented, but also documenting acknowledgement of and compliance with those policies and precautions in real time as they're rolled out, such that when a lawsuit is filed, almost a year from now, and again, our reasonableness standard has shifted tremendously, you can look back and say on X date, this is what our policy was, this is what the intent was behind it, and this is how we acknowledged and documented compliance with those policies. So with that, I will turn it back over to Mark.
Great, thank you, Shevon. That concludes our speaker presentation for this panel. I think we have time for a question or two. Yes, Shevon, first question for you. Force majeure clauses are going to be the subject of a lot of litigation. And the question here is, how are courts going to deal with COVID-related guidelines versus laws? You mentioned, for example, that OSHA can enforce, but OSHA doesn't have a specific COVID standard right now. There's no regulation. They are enforcing under the general duty clause. So how do you think courts will deal with general guidance versus actual laws or regulations?
So I think that, sorry, can you hear me? Great. So I think that's going to largely depend on your jurisdiction. And I think we're going to have the normal, usual suspects, the states that are more friendly to consumer claims and employee-related claims. Up to this point, there, as Nelson had mentioned, there had been the overarching guidance that you have this force majeure provision plugged in there, and everyone knows that it means something crazy happening, but it doesn't have to specifically say what that something crazy is. And I think that what's going to happen moving forward is that courts are going to look at their common law, and again, whether that reasonableness component is a part of it, as well as foreseeability, and that's another component that should be thought about with respect to some of your policies and best practices moving forward. In that, it may be that that particular state will not say that guidance was merely enough when it was foreseeable that there were additional standards that were required. And so I certainly foresee in a lot of jurisdictions there being a showdown, so to speak, between the guidelines of a particular organization or the CDC versus state guidelines and state laws. Some of the state liability limitation laws actually address that. And in some states, they say that businesses have to comply by either federal or state or local guidelines, and give businesses the option of which to pick. While others are more stringent and say that you have to abide by the local guidelines, and those are oftentimes places that have looser local guidelines. So it's an excellent question, because I do foresee a showdown, guidance versus laws, and I think it's largely going to depend on where your usual bench sits, or where your usual bench falls on some of the general concepts of how broad consumer protection or employee-related claims may be.
Mark, this is Mike Droke. I had a question was asked by one of the attendees for Monica Johnson. You'd referenced that it's important to communicate and over-communicate with the various constituencies. And as well, Shevon talked about the importance of documenting activities and events, which sometimes can create more problems than the documentation solves. And so can you talk to how companies are balancing that tension between communication and documentation of things you wish hadn't been there in the first place?
Sure. Thank you, Mike. Absolutely. I'm happy to talk about that. I think that's the classic where you always have legal saying you've got to be careful not to create Exhibit A. You've got to be mindful of that. But also you have to not only wear your legal hat, but you have to wear your strategic business partner hat. And that's really, from an in-house perspective, especially heightened by this pandemic, that's even more necessary. So how do you do that in this question? I mean, it's being part of what is being developed and what is being presented as part of PowerPoints. That's sort of, if you look at limiting the responsibility there, but also look at it on the other side of it on an offensive basis. So for example, with your board of directors, you're going to want to make sure that you're creating minutes that record the fact that they are executing their duties as to those mission critical tasks. So there's no prescribed, this is when you create a document, this is when you don't, but it's really looking at the situation, balancing the risks and using your legal expertise as well as your strategic business partner hat.
Yeah, and I should qualify that as saying that as far as documenting everything, really thinking, as Monica said, with your legal hat, and more so documenting official policies as they roll out. Rather, it's not going to cut it to say we told everyone during a staff meeting, or that we had the managers mention it while they were discussing morning duties. And so really thinking more towards an official standpoint. And also, we could spend a whole hour talking about best practices of documenting things. So feel free to call me with questions. But also, as Monica mentioned, making sure you limit those that have the ability to document things, such that you're again focusing on the right priorities and making sure you're setting yourself up to be best positioned should litigation come down the pipe.
All right, terrific. Well, Mark, thank you so much for moderating this program. Fascinating, and to say that we're in extraordinary times doesn't really give justice to the concept. Monica, Nelson, and Shevon, thank you for really super helpful information and really a great basis too for looking at other ways that we're managing risk in today's world.